Good morning.
Good morning, Your Honor. I'm David Kelston, and I represent Judy Bernier, the wife in this case. With me is Mr. Theodore Tedeschi. This case revolves around two factual matters that really should not be disputed. First, the parties here were married for 35 years. Their property was all marital property. They stipulated that each had contributed equally to the creation.
I have a question for you, please. To what extent, I've read the briefs and I've done some extra research about the cases and the literature, and I know that at one time what the husband's expert was saying was generally accepted in the appraisal industry, so to speak, and then that changed over time. To what extent did were the changes in the law brought to the attention of the probate court judge?
They were brought to the attention of the judge, Your Honor. The cases, the relevant cases, the Gross case, the Adams case, the Wall case,
Which is the Delaware case?
These were all brought to the attention.
Which is the Delaware case?
You don't mention the Delaware case.
Which is the Delaware case?
I'm sorry.
Okay.
Delaware.
The Delaware case is the case.
The Rhode Island?
No, there's no
Delaware.
case. Is Delaware Open MRI. Delaware Open MRI. Radiology Associates versus Kessler at 898 Atlantic 2nd, 290. I'm not sure that was even decided at the time that this case was. When was the case being tried?
The case was tried in 2002.
Yeah, that was a decision that was reached in 2006, so of course you wouldn't have brought it to her attention. But to what extent did you bring these other cases to her attention, and at what point? Not just in the post-judgment letter.
Well, Your Honor, I entered the case post-judgment, and the pre-judgment cases, the pre-judgment pleadings or memoranda are not in the record, but I know that.
That's why I'm asking the question.
I'm almost certain these cases were cited because the judge distinguished certain of these cases in her judgment.
Did the judge refer to the Gross case in her judgment?
I don't believe so, Your Honor.
No, she didn't. And did she refer to the other cases in the judgment?
She did. She said the Gross case, for instance, was distinguishable because it was a minority interest. The Adams case, we pointed out, was not a minority interest.
Why did it take 5 years for this case to get here? This was tried in 2002, wasn't it?
Your Honor, I think that's an important point. It was tried in 2002, and if you look at the transcripts, the parties were expecting and the judge was expecting the trial to be concluded really within a few weeks. The trial was not concluded until May, and then the first judgment wasn't handed down until August of 2003, more than a year later.
And that caused one of the problems in the distribution
Equalization. Exactly right, Your Honor. Exactly. But, Your Honor, getting back to your question, the literature prior to this case was somewhat distinct and different. There were some experts who said you ought to tax effect, some experts who said you should not tax effect. There were no cases that said you ought to tax effect. And now I think
even if you tax effect, excuse me, Mr. Even if you tax effect, that's just the first threshold. In what way do you tax effect?
Yes.
It seems to me it goes to the core of what's at issue here, correct? Yeah. I'll ask Mr. Kane the same question, but why would you tax effect a Chapter S corporation as if it were not at the regular corporate rate when there's unequivocal evidence that nobody's planning to sell this company?
And, Your Honor, I think that is absolutely the core of the issue. That Mr. Horvitz, Stephen's expert, dealt with all of these matters in an abstract way. He had tax affected every one of 250 S corporations he had ever appraised. He didn't look at this case in its details.
Can I ask you a question? He didn't tax affect it at the corporate rate. I thought he tax affected it at the personal income rate.
There's a little ambiguity about that. He did tax affect at a rate of 35%, right. And we did identify in the record where he says, I am tax affecting at the corporate rate.
Did he have any way of explaining why he was tax affecting at 35%, other than saying that was the couple's tax rate?
The couple's tax rate was actually lower. It was 27%.
Okay. That's one of my questions.
What he said was, and this is simply wrong, he said, eventually we all pay the taxes. Well, no, that's wrong.
Eventually we don't all pay the taxes if you're an S corporation.
Right. He said, and the court said the same thing. The court said, I disagree that there are going to be fewer taxes paid at the entity level and more cash flow. That's simply wrong as a matter of fact and a matter of law. That's a clear error of law. And I think all of the authorities agree now that you don't do that, you don't tax effect, unless there's strong evidence that the S corporation is going to become a C corporation. Here, the evidence was all to the contrary. It had always been an S corporation. It was going to be owned by Stephen, and he testified it wasn't for sale at any price to anybody. So it was going to be an S corporation. And by deducting 35% from the income of the S corporation for dividing by the capitalization rate, remember, his capitalization rate and the overall income picture were about the same for the two experts. By tax affecting, he reduced the value of the markets, a fictitious reduction, by $5 million.
In what manner were the cases after Gross brought to the judge's attention? Through memoranda or through cross-examination of the husband's expert, or what?
No, through memoranda, Your Honor. As I
Memoranda.
remember.
Are those memoranda are they in the record before us?
They're not in the record that we
appendix.
have submitted, but they are in the court's record. Your Honor could find them. And again, they were lengthy. There were probably 300 or 400 pages of post-trial memoranda submitted
But there's no
by the
claim
parties.
here. But there's no claim here in any event, as far as I can see, by the husband that this was not a live issue at trial. Correct?
Oh, it was the central issue
That's
at
what I'm
trial in
saying.
terms of valuation. Both experts said, we basically agree on most things. We agree on the capitalization rate. We agree on the income. We disagree on tax affecting.
And you disagree on key man discounting.
On certain discounts, right, and those discounts led to another reduction that totaled $3 million. But the experts said we basically agree on how to do this, what the numbers are. We disagree on tax affecting. And Mr. Lester was very clear. He gave examples. He said if you have $100 income and it's a C corporation, the owner ends up getting $65. And there's no way around that. That is what happens. If you have an S corporation and it has $100 income, the owner gets $100.
And pays tax
Right, and
But
on
then
the
you-
$100.
and pays tax on that. But at the end of the day, he's left with about 50% more income, the owner, than he would have if he had converted his corporation to an S corporation. And that's why the government set up S corporations for small corporations.
But doesn't
back
that
in the 50s.
doesn't that dictate that it doesn't affect whether it should be tax affected, but the way it should be tax affected? I mean, the rate or what the tax affecting formula should be?
I think what the cases say now, Your Honor, is that you simply, if you tax affect, you tax affect at a zero tax rate at the corporate level. And that's what the Adams case says, and that's what all the cases
So
seem
that's
to
not
be
tax.
saying.
I don't know how that's tax affecting. That's saying 0 times anything is 0, of course. So it's not tax affecting.
Exactly. So they're saying the rate you apply is 0. You don't tax affect. This fits within the general divorce case law. I think that goes back.
But excuse me, you say that all the cases now say that you don't tax affect, but this Delaware case, Delaware Open MRI, I don't believe said that. And that was a case from the Delaware Chancery Court, which certainly deals with these business valuation cases all the time. There, the court said that an S corporation's fair market value would be somewhat greater than if it were taxed as a C corporation, but not quite as much as its freedom from entity level tax might suggest. And it there concluded that the appropriate rate should be 29.4%. After going through trying to quantify in monetary terms the tax benefit enjoyed by shareholders of an S corporation versus a C corporation, and imposing hypothetical tax rates. So it isn't that all the cases are saying 0 tax effect.
All right. I accept that, Your Honor. But I do think that at the entity level, you simply can't apply a taxation, an imputed federal tax, and deduct that because the S corporation is paying no federal tax at that entity level.
But that's why it's imputed. Of course it's not being paid. It's
Right,
imputed
right.
because someone is going to pay a significant tax on that income.
But that happens, Your Honor, in the C corporation or in the S corporation. Whatever ends up with the owner is going to be taxed. And both Mr. Horowitz and Mr. Lester said, look, we look at after entity tax cash flow, and we say how much money does the investor have. We take the amount of money the investor has and we divide that by the capitalization rate. And that's how we figure out the value of the business. And in this case, if you think about it, this is a business that's throwing off $3.6 million to its owners every year. And if you tax affect it, the value ends up being under $8 million.
Well, let me
2
ask you
years
this.
of income.
Assume that we agree with you that there was some error here and that it was clear error. What do we do? Do we remand it to the judge to apply? Do we set forth what the appropriate law is at this point and remand it
Well,
for
it's
the
fact
judge to
specific.
apply it, or do we say? And what would you say is the proper approach?
I think this court would announce a rule that tax affecting is only appropriate at all if it appears that the corporation is going to become an S corporation, which is not a C corporation, which is not the case here. And you remand the case for recalculations of its value without the imputed deduction of 35%, because at least in this case, there's no basis for deducting the 35%.
So you say that we should impose a zero, no tax affecting?
No tax affecting, and then the owners have a certain amount of money, and based on that amount of money, both of the experts would then probably agree on the valuation. And the court should also remand on the equalization matter, and then I think say once those matters are taken care of, the court should look at alimony and see if the alimony award is sufficient, insufficient, or maybe excessive in light of the fact now that additional money has gone from the markets essentially to the wife. But I think that is the appropriate course of action for this court.
So you're suggesting this is a question of law, not of fact?
Right.
I think this is definitely a question of law,
Right.
Your Honor.
But given the fact there's this new case from Delaware, which doesn't seem to say tax affected zero, how do we decide?
Well, the circumstances are different, correct? You're looking at a divorce settlement.
Yes.
But we're valuing a going concern, so it's more.
But you're
You
valuing.
can say the circumstances are different, but we're still trying to get the market value of this.
In
business.
this case, so this is really a fairly simple case because you have either one or two owners of a market which kicks off about the same amount of money every year. We want to know, after it kicks off that money, how much are they going to have that they can spend before they pay their taxes. That's how valuations seem always to be done. So it's fairly simple in this case to say you're going to take the $3.6 million, you're going to take out a salary for Stephen. I think at trial they said $300,000 was a reasonable salary. You're going to do some other adjustments on intercompany loans and the like. You end up with about $3 million, and then you divide that by the capitalization rate. It's a fairly mechanistic calculation, and you come out with the value of these markets. Putting aside the other deductions, it will be about $13 million. If the other deductions were improper, the value will go up to a bit over $16 million. I think the other deductions were clearly improper. Again, it's the same sort of abstraction. We don't look at this particular market in this particular case. We look at some economic abstraction, which says we always take a marketability discount. Mr. Horowitz said the marketability discount was the cost of selling the market. It's not being sold. It's being transferred to Stephen.
Okay, but to go your way and do everything what you, I agree that it's a question of law. I think that it is, but we would have to say that the law was clear at the time, was so clear at the time that the judge decided this, that you don't tax affect an S corporation except in a certain circumstance, that she should have known this, and that you made that sufficiently clear to her through your submissions.
It was the central issue at trial, Your Honor, I think, between the two experts.
I know that the
Yeah.
difference in valuation was the central issue at trial. That's absolutely clear. But what I'm less clear about is how much you informed the judge of what the current state of the law was.
Judge, we could provide a post-hearing letter to that effect, but I think
But
I think there was full information. I remember.
Mr. Kelston, in any event, what the judge is required to do here, because am I correct that there was no claim that this shouldn't, that whatever happened to the property after this lengthy marriage, it was to reach as close as possible to a 50-50 split. Am I correct?
Absolutely,
So
Judge.
that's the law that is clear. If the
Correct.
judge imposes on that some calculation which ends up where it is patently not 50-50, there's been no change in the law. The judge could have done it some other way, but the net effect of which would be 50-50, and you'd be having a hard time up here persuading us to set that aside.
Yeah. And, Judge, it wasn't as though the law was established at the time of trial that you do tax effect. Nothing was established one way or another, and simply here a fictitious tax was imposed that reduced the value significantly, and thus justice wasn't done.
Oh, excuse me, I just want to be sure I understand what you're saying. You're saying now that that the law was not clearly established at the time of trial?
By no means, Your Honor, if you...
I just heard you say nothing was established. Maybe I misunderstood.
Nothing was established.
So how is the judge plainly wrong?
With respect to, because the net result is not 50-50.
The judge was plainly wrong, Your Honor, because she wrote in her rationale and she said, I disagree that an S corporation pays fewer taxes. Now, that's plainly wrong. You don't have to be a tax expert to see that. S corporations pay and have paid since the 1950s less in taxes. So that was plainly wrong, I think, regardless of what the authorities said. And the authorities were appraisers who seemed to be kind of all over the place on this. So,
Well, if there are two experts before the judge, and one said, and they're each properly qualified, you haven't argued that the husband's expert wasn't properly qualified. So if each expert is properly qualified and each expert presents a different theory to the judge, and no one informs the judge of what the guiding principles are, then isn't it permissible for the judge to go either way? Because there would be evidence to warrant her finding.
the judge was informed of the case law, Your Honor, and I think it wouldn't be permissible if one expert was patently incorrect, just patently incorrect, in saying that taxes get paid sooner or later.
Well, how do we know that one expert is or how did she know one expert is patently incorrect?
She knows a lot more than I know about this, Judge, and she heard the trial. And the statements of Mr. Horowitz had no basis at all in fact or law.
How did you show that?
By citation of the case law having to do with S corporations, which says they don't pay this tax. They don't pay this tax.
And by that, you mean that, the gross and the following cases?
Yes, yes. Okay. Your Honor, if I might make just one comment on alimony.
I'm afraid, Mr. Kelston, your time is up. I can assure you that we will read your briefs and everything that we need to.
Thank you, Your Honor.
Mr. Kelston. Mr. Kane?
Good morning, Your Honors. My name is Paul Kane. I represent Stephen Bernier. With respect to Justice Cowan's question, the Gross case had been decided just prior to trial. And the Gross case, I think as I'm sure the court read in the Kessler case, the Delaware MRI radiology sort of knocked valuation theory on its ear. The Gross case was new law out of the tax court.
What about the two cases that followed?
Those came, Your Honor, I believe, after trial.
Mr. Kane, let me tell you what my problem is. Let's assume, we may or may not agree with the Delaware Chancery Court, but let's assume that the valuation of an S corporation, as articulated in the Gross case, is just wrong. It's just wrong, right? So the judge may not have understood it. The judge might have understood it. But if the factual underpinnings are incorrect, surely that's a legal error that can be corrected on appeal.
Factual errors of this case?
Well, how
or
you
distinguish from Gross?
value a corporation. Let's assume that you know, and frankly, we've had a slightly different context, but trial judges get presented with, at the time, new DNA evidence, and how do you know, what's the correct amount of testing, and how much, what are the inferences that can be drawn, and, you know, the science develops and the understanding develops, and, you know, courts all over the place are trying their best to deal with it, and then it turns out that the basis of a decision at trial, with the judge notwithstanding doing the very best he or she can, is just incorrect.
I suppose, Your Honor, applying that, although as this Court knows I'm not real familiar with DNA, applying that to this case,
Right.
you look at the Gross case to see whether or not that is a, let me call it a realistic precedent for what we have here.
Well, just
But
one
this
minute.
company was, your client, I mean, it's unusual. Believe me, it's not, at least it struck me as unusual. Your client was unequivocal. I'm not going to sell this corporation, over, essentially saying, over my dead body.
It happens, Your Honor, in virtually every divorce case, but one thing that the experts agreed upon was what their mandate was, and that was to determine fair market value, which each of them defined as follows: the price at which the property would change hands between a willing buyer and a willing seller, neither being under any compulsion to buy or sell, both having reasonable knowledge of the relevant facts.
Well, that's always
That's
the
been the
question.
standard of fair market value in
That's
this
always
Court.
the question, whether
Correct.
it's a house or a store or
That is
a
correct.
car
And it's
or
a
anything.
hypothetical sale. And it
It's a
always is.
hypothetical sale. The
Yes.
problem is that in a house, or indeed a closely held C corporation, or in a, you know, antique motor car collection or anything else, even if the person is saying, I'm not going to sell, it doesn't make any difference. Here it makes a difference because it's an S corporation.
Respectfully, Your Honor, I don't see what the difference between...
Because the net effect, the impact on the spouse, it could have been Mrs. Bernier, it could have been Mr. Bernier. It so happens in his case that he's the one who's going to continue to, as I understand it, run the business and so on. It has a dramatic impact if you look at the two parties at the end of this hypothetical situation. If you've got an antique car collection and Mr. Bernier is not going to sell it, the antique car collection has a value so that when you've divided up the property at the end of it, he's left with, you know, something that makes no difference whether or not it's sold or not sold. It's a static, I mean, it may appreciate in value, but it's a static value. An S corporation is not a static value because it's going straight through to your own personal taxable income level.
That, I think, Your Honor, would require a major change in at least my understanding of valuation theory, and that all S-corps in divorce cases now would be valued different than any standard I've ever heard of.
Okay. Mr. Kane, to go back to
Yes,
what you were talking about, Adams and Heck, I guess, were 2002 tax cases,
Right.
tax court cases. Wall was a 2001, which was the same year that the Sixth Circuit approved Gross. So from what you're saying, then possibly at the time that this case was decided, the law was in a state of flux.
Gross had clearly been decided,
Right,
Your Honor,
but-
because I remember that was discussed at trial with both experts.
Well, isn't a lot going to depend on exactly what the state of the law was at the time that this case was tried?
The state of the law, at least as I understood it at that point in time, Your Honor, was the only case
It-
that had spoken to tax affecting was the tax court and the circuit court's case in Gross.
In Gross, but
All
what
the
about
other
in the
cases-
post, what about in the post, were these post-trial or post-judgment memos that raised the subsequent tax court cases?
Then you have Adams and Hecht, which,
Right.
interestingly enough, in both
Yes,
of
but was that brought to the attention of the judge? That was a
I believe
motion
they
to
were
amend
in
judgment, though.
post-trial pleadings. As my brother pointed out, there were pages and pages of memos filed post-trial, and I believe both those cases. What's interesting about those cases, Your Honor, and of course it's always hard to figure out how people get there, but while the court rejected in each of those cases the idea of tax affecting, in each case the court reduced the amount that the IRS said the shares were worth by approximately 33%.
What did the Gross case
Even-
say the tax effect should be?
In Gross, they said there's no tax effect, Your Honor. Gross, however, was
I said 0%. correct?
0%, yes. But as some commentators have suggested, Gross was in many ways a perfect case in the sense that there was a restrictive restriction in the ability to transfer stock. It was minority shares,
No,
and
I
they
understand
always
that.
paid out 100% of the net profit.
So
That's not true here.
What you're saying, in effect, is the later cases really said no tax effect, but they really did something that was very similar to what occurred in this case.
The end result, if you look at the numbers, Justice Graney, that's exactly what happened.
So for practical purposes, the landscape has not changed.
If you look at what happened in those cases, that's correct. And it's interesting that the reduction from what the IRS's position was is 33%.
Because the general rule, I think, and you may think about this, is if the landscape and the legal principles changes between the time of trial and the time of appeal, the appellant might get the benefit of that.
Possible, sure.
I mean, that's what happens, at least the criminal side, with the DNA cases. We've had civil cases where the landscape has changed. I don't know.
I think the Chancery Court is the first state court that's really looked at the issue.
The
since
Delaware
Adams.
case.
Yes, the Kessler case, am I right?
Right.
And there the judges, as Justice Cowan knows, said, no, this just doesn't make sense. You're putting too much value. And if I can just show by a short example, if you think about...
So that would sort of indicate that the law is actually still in a state of flux.
Yes, the court can certainly look at it that way,
It's
but
not
I
in
think
a
the end
state of
result
flux.
is that there's got to be some adjustment here, that we simply can't suggest, as Justice Cordy mentioned earlier, that someone's not going to pay the tax there. At the end of the day, if we're dealing with a hypothetical buyer, hypothetical seller,
Yeah, but we're not dealing, because one of the things that happened in Gross is there was a limitation. Your client was the one who said we're not going to sell it. So why would you treat it as if it were being...
because that is the legal standard of fair market value on which the experts agreed, Your Honor. That's what they
Let me explore that with you for a second.
Yes.
Could the judge, within her discretion, have ordered a sale of these markets?
Judge did. The judge gave basically options in the judgment, Your Honor. The judge said
but could she
husband
have
can
ordered
buy
a
out wife, wife can buy out husband. If the husband doesn't buy out the wife, if she wants, can buy out the husband. If neither one wants to, it'll be sold.
Okay.
Can I go back to the point on the experts agreed? That means counsel agreed as well, did they not?
Yes, Your Honor.
So the stipulated method of valuation here...
It wasn't, I don't want to be incorrect now, there was not a stipulation, but trial testimony was from each expert. That was the standard of value.
It's the law of the case.
It's the law of the case. It's the law of
Yes,
the case,
yes.
because nobody got up and objected and said, oh, no, no, no.
Correct.
We're
Not going
challenging this
concern value,
expert.
not exactly.
But it doesn't follow that your expert necessarily was correct.
Sorry, Your Honor, I don't understand the question.
Well, I mean, both
No,
the
it doesn't
experts
follow
tested.
that either expert was correct from
Correct.
that. That's one has nothing to do with the
They
other. That's apples and
hypothesized
oranges.
a willing buyer and a willing seller. That was the hypothetical standard. They then made their analyses and came to the conclusions that they came to. The difference is, at the end of the day, how does it get paid? We can talk about tax affecting or this or that, as Justice Cordy pointed out. Someone's going to pay the taxes. What's the buyer going to look for? How do I pay for this transaction? At the end of the day, there's earnings, or net profit. Those are going to be taxed at the shareholder level, at the owner's level, at the shareholder level. No question about it. So the buyer is going to have less dollars to pay back that debt. If it's a C Corp, it's taxed at the corporate level. He has less dollars. If I may, Your Honor, just briefly, how one becomes an S Corp is relatively simple. The accountant fills out a form which complies with the IRS code. It basically says you can't have more than 75 shareholders, you can't have more than one class of stock, and all the shareholders have to be citizens of the United States. You then sign it. How long does it take one of us to sign a signature? Let's assume it's a second. So now the shareholder has elected 1 second to exercise this right. And if we compare the two C Corps and S Corps, assume, if you will, Your Honors, you have two companies, S Corp, C Corp, that are exactly identical. Not comparable, but 100% identical. The corporate, and let's assume they have $100,000 of profit at the end of the day, at the end of the year, excuse me. The corporation is going to pay a tax, C Corp, at, let's say, $40,000. S Corp pays no tax at the corporate level. The net income after the corporate tax is paid is $60,000 for the C Corp, $100,000 for the S Corp. And let's assume that the capitalization multiple is times 6, or 16.6% cap rate. That would leave an indicated value for the C Corp of $360,000, an indicated value for the S Corp of $600,000. So now you've got a value of not tax affecting of 66.7% greater for 1 second of signing your name.
It's not 1 second of signing your
It's all you
name,
do,
Mr.
Judge.
Kane. That sounds like a great jury argument. It's
It's all you
not
do,
1
Judge.
second of time. No, you don't. You do the probate and family court. It's a careful consideration, given the circumstances of the owners, as to whether or not they choose to be taxed in a certain kind of way.
Don't disagree with that.
And it seems to me that when you come to divide the property where it is agreed that they are co-equal owners, that you don't treat it as if it is a C corporation, because it isn't.
But the end of the story here, Your Honor, is value, not what it is to the
The end of
shareholders.
the story is, what do these two parties receive from a 35-year investment of time, effort, energy, and money, and everything else, sweat, and everything else? What do they get out of it?
The divorce, I agree with you, Your Honor. The judgment, that's correct.
The day after this was signed, it continued to be treated as an S corporation.
That is correct.
There was no payment of corporate capital, of corporate taxes.
That is correct. But that's true in virtually every divorce case involving a business, Your Honor. And yet the standard has always been, not only in this
Well,
jurisdiction,
maybe it's just been terribly unfair for a very long period of time.
is a willing buyer and a willing seller. That's been the standard.
Counsel, can I move to a slightly different tact on this?
It may have been a willing buyer and a willing seller buying an S corporation, so the next buyer also has an S corporation.
The next buyer could change it to a C, Your Honor.
But the next buyer hasn't changed it.
I understand
We
that.
have an S corporation.
I understand.
Right? So you can have a willing buyer, willing seller. I'm happy with that, but you've still got an S corporation, and it's being valued, as far as I can see, as a C corporation.
Respectfully, Your Honor, it's been valued with at the end of the day, with taxes or a number being taken out.
A number
As
being taken
MRI
out as if it were a C corporation.
No, to recognize the taxes that need to be paid, as the Kessler says.
If we didn't
Kessler
value it
says.
at market value, what would we value it at?
I think it is market. I
Well,
think that is
I
the purpose.
agree with you, but I'm responding to the argument that the Chief Justice is making,
Not
that it's
an
not
argument.
market value. What do we value it at if we don't value it at market value?
The only other, seems to me, it would have to be something called going concern value or
You value it at market, but it could be
some
an S
other value,
corporation.
some other standard of value. I'm sorry.
You have to take maybe the income approach and
You could do that.
These both were the income approach, Your Honor.
Could I
Well-
ask you to speak for a minute on the equalization issue? The judge just dismissed the wife's equity action here, but it would seem that a decision is necessary on that issue, and I don't see why the wife isn't right. The stipulation covered a certain period of time, and the trial went on much longer in the decision than anyone expected. And why wasn't the wife entitled to half the money that the husband was taking out during that time?
First of all, Your Honor, the evidence wasn't that the husband was taking it out for his own benefit. The stipulation was as follows. Mr. Bernier was limited to how much income he could take.
I'm sorry, he was what?
Limited to how much income he could take from the companies. He had to pay taxes. He had to pay the money for Rosewood Farm, that $600,000 a year loss. Legal fees, both sides came out of those funds. Expert fees came out of those funds. At no time during the proceedings did Mrs. Bernier, or for that matter, Mr. Bernier, put on their respective financial statements that income is either income or an asset. It wasn't until after the case was over that Mrs. Bernier decided she should get that asset. There's no case that I'm aware of, federal or state, that says that a shareholder of an S corporation is entitled to a distribution. The shareholder of the S corporation is obligated to pay his or her share of taxes based on his or her proportionate share of net income, whether the income is distributed or not. Typically, as the courts have said, what many S corporations do, they distribute enough money to pay the taxes. Otherwise, S corps would never grow.
The question is, one of the questions I have is, was there undistributed income? After these expenses which were approved, were paid, was there undistributed income?
At the end of the day, Your Honor, I can't give you an exact answer on that. At the end, I know there are an awful lot of expenses paid out of, for example, legal fees alone.
The wife's
Legal expert close to
brief
$2
at
million.
least indicates that there was undistributed income after the fee, sizable undistributed income.
That also suggests, Your Honor, forgets how much was paid for all of these other items. By stipulation, if you go back and look at the stipulations, which I know are in the record, all the expenses, the family had what they call the 180 account, which basically paid all kinds of
Well,
family.
suppose it's a small amount. Suppose it's only $10,000, which in this estate is a small amount. Would the wife be entitled to half of it?
I don't think so, Your Honor,
Why
because
not?
otherwise, how does a company get run? If we did that in every case, well, then you'd be dealing with an S corp or a C corp. Wouldn't make a difference.
Yeah, but the
Or
legal
any
fees,
business.
But it was
the legal
run.
fees didn't have anything to do with the operation of this company.
No, but the monies were paid out of the cash flow of the company, Your Honor. During the litigation, all of
Why should they get factored into the valuation?
not into the valuation.
There weren't.
I'm sorry, I was addressing the issue of equalization.
Oh, I'm
We're
sorry.
talking about, the,
Yeah.
basically
Sorry.
the money that was earned and not distributed
During the
this 3 or 4 year period of time.
Right.
And whether or not there should have been an equalization at the end of that.
I'm
Because that
not-
has nothing to do with how the asset was valued, because it was valued at a date prior to this accumulated income.
And the expenses of the company must have been paid out already because it was a going company.
Oh, yes, those are the
Okay.
deductible expenses, Your Honor.
Right.
Then they paid out all of these non-deductible expenses on which they paid taxes, obviously,
Okay,
because they can't
right, so
deduct
what's
them.
left, whatever it is, why wouldn't that be subject to a split?
If the court wants to adopt the position that in a divorce case, income is to be split 50-50, which is basically what the court's saying, that would be inconsistent with any case I've ever read here, and certainly inconsistent with Section 34. But that would be the net effect of that rule. That
But
during-
but you wouldn't make a general rule, it would apply here because the parties had agreed.
to an equal division of the marital estate, not
Yes.
income. Not income.
Not-
If you apply that, the court's logic to, say, a pending divorce case where there isn't a stipulation, would a non-working spouse, husband or wife, doesn't make any difference, have a right to that income earned during that period of the divorce as an equitable right? So should it be put in escrow pending a divorce case, divorce decision? Maybe. But that would require a new law and different, certainly, than Section 34. But that's the next step, Your Honor.
Why, as a matter of law, the key man discount allowed for this kind of a business?
Because both of the experts, again, while they agreed on a fair amount and disagreed on others, they both agreed that Mr. Bernier was, in their words, both used the same words or adopted the same words, the whole show.
Yeah,
But there was
that
no
doesn't make
indication
him-
he was leaving. I mean, unless he, heaven forbid, dropped dead, there's no indication that he was going to sell it or become unavailable to the business.
That is, Your Honor, in the cases we've cited in our brief, the valuation theory reason why they apply a key man discount in valuation theory.
It seems to
Again,
me-
it's a willing by willing
It seems to me that the judge is simply closing her eyes to reality. When you talked about the Gross case, the reality was a restriction on the stock. You could say, well, that's too bad. You can't close your eyes to the reality.
Sorry, Your Honor, I'm missing the reality then.
Well, the reality, even if the company was sold, many, many, many times the key man remains an employee of the new company.
That's not, again, Your Honor, with all due respect, you're putting standards on a sale, which the case law does not do. There would be no evidence to suggest if Mr. Bernier sold the business, or Mrs. Bernier sold the business, that it'd stay on. Where is the evidence that it would stay on forever, never, never?
Can I ask you a question, though, that goes to this? Apparently, whatever the valuation was, it was a super deal, because both of these parties wanted to buy it and were prepared to put the money up. So the discount certainly made it a really good deal. So the question comes, how come the husband got first choice? And if the husband gets first choice, why should then the key man discount and all these other discounts apply when they're irrelevant?
The husband got first choice, I believe, Your Honor, because he had been running the business since 1994. There was evidence at the trial that if he was not running the business wouldn't last very long.
They could have sold it
Because
to
he was
Stop
the
and
one who
Shop.
would run. I'm sorry, Your Honor.
They could have sold it to Stop and Shop.
If they sold to Stop and Shop, we wouldn't have the S Corp problem because Stop and Shop is a C Corp.
You'd have $9
And
million.
Can't
then
have
you
it
lose the
both
S Corp.
ways.
No, but that loses the S Corp value, Your Honor. And Stop and Shop is not going to say, I don't think, I'm going to pay you a premium that I can't use as a C Corp. I
But here's
can't
my
imagine
problem. If the
doing
husband
that.
was given the first choice, it was because he was the key man. So
That is correct.
So why do you take a key man discount when the key man is given the first choice to buy his business? And that really doesn't make sense to me. I understand fair market value, but then the decision comes, who gets the first choice to buy?
It goes back, Your Honor, to the theory behind valuation, the willing buyer, willing seller. If Paul Kane is the buyer and Paul Kane has the equity to buy it, but doesn't have the ability to run the stores, what is it going to cost Paul Kane to hire someone? And it's not going to be $350,000.
Yeah, so
It's going to be more
she'd had
to
the
rent
first
it.
choice. Maybe you discounted for that. I don't know. Mr. Kane, thank you. You were
Thank
trying
you
to
very
close
much,
out.
Your Honor.